There we go. That was the problem. People were waiting for us to start. So we have 41 attendees, 50. Okay, the number is just shooting up. Sorry, folks. We had technical difficulties this morning. I will be introducing Jennifer as Lorraine. Ah, wonderful. There's Lorraine. Asking Lorraine to unmute. Sorry about the technical difficulties this morning, folks.
I am on.
Looks like we've got 100 people in already.
Excellent.
Sorry. Go ahead, Lorraine.
Good morning. Welcome to all guests and members for the new program year. We have 5 new members. Andrew Parisian, CFP, Canandaigua National Bank and Trust. Kevin Schultz, CFP, with Mapstone Veritas Financial Group. John Maurer, CPA. Audrey Gray, attorney, MPH, Harris Beach. Daniel Schmitz, CFP, AIE, CLTC, Oakwood Financial Services. Please keep in mind that members are required to attend 2 meetings during the fiscal year from September through June. Be sure to stay on the Zoom after we adjourn the meeting, as a program evaluation form will pop up on your screen. I would like to ask Don Twitmeyer, the program chair, to make a few remarks about our upcoming programs.
Good morning. I apologize that the video is not working right now. It was working about 10 minutes ago, but then it quit on me. I just wanted to briefly mention the upcoming programs for the year. Our program committee has been busy. Our next program is going to be the joint program with the New York State Bar Association on October 30th of 2020. And it's co-chaired by our own Elizabeth Thorley on behalf of the Estate Planning Council and Kelly Guzmano on behalf of the Monroe County Bar Association. The topic will be on cybersecurity issues. And our speakers will be Stima Fowler from IconicIT.com and Nicole Black Esquire from My Case Law Practice Management. It should be a very interesting program coming up, and we hope all of you will be able to attend. In December, we're planning a program on an update on estate planning for digital assets. It's been about 4 years since we've had the fiduciary access to digital assets law, and we want to follow up with that on different considerations that we've come across over the last 4 years in terms of getting access to the assets, and also on the other hand, shutting down those assets as well too after death. So we're in the process of obtaining speakers for that, and we'll give you more details coming up. In January, we have a program on succession planning and family drama, how we all can help, featuring Dr. James Kestenbaum of the Solutions Group and another speaker as well too. We just want to follow up with respect to the joint program from last year, in which we had business succession issues discussed, but this will be more from the family aspect of it and some of the non-business and the non-tax aspects of business succession planning. In March, we've got a program coming up on Medicare, Medicaid, and healthcare cost considerations during retirement. And we're looking forward to finalizing the details on that program in the next month or so. In May and in September, we've got 2 different programs coming up on changes to estate planning and changes to tax planning with respect to the pandemic, and also with respect to the presidential election that's going to be coming up. Depending on who wins, there's going to be different changes we expect. And when we're going to have those programs, whether the estate planning or the tax planning programs, will depend on when the legislation comes through. But there's also different considerations with respect to the pandemic. As all of you have known, you've probably been getting a lot of calls about estate planning and updating of wills and healthcare proxies and living wills and powers of attorney. And so we hope to have a good program on that to deal with both the legal and medical and ethical issues. That's what we've got as a lineup for the coming year. If anyone would like to participate in the program committee, please let me know. Just send me an email and we'll be happy to let you know about the next meetings. This is where you can provide your input with respect to those meetings.
Thank you so much, Don. Before we continue, I would like to thank our 2020 Platinum sponsors, Best Times Financial Services, Canandaigua National Bank and Trust Company, ESL Trust Services, Finger Lakes Financial Services, and Thorley Wealth Management. If your company would like to be a sponsor, please contact the Estate Planning Council office or Communications Chair Vicki Kleehammer, AEFPR group. So without further ado, I would like to introduce our speaker for this morning, Jennifer Flannery. She is the co-chair of the Trust and Estates Practices of Barclay, Damon. Jennifer.
Thank you very much, Lorraine. Good morning, everyone. Thank you so much for having me. I really appreciate being able to speak with such an esteemed group. And as we round into, I think, month 7 of the pandemic, the fact that everybody is on Zoom bright and early this morning and isn't suffering from Zoom fatigue and is attending is a real testament to the cohesive nature of this group. So I really, really appreciate being able to be here this morning. You know, when I was asked to speak originally and think about some trust litigation issues, particularly for a group of sophisticated T&E practitioners, accountants, trust administrators, insurance agents, financial advisors, you know, a lot of the things that you would speak with sort of a regular group, you all know. So what I thought I would do this morning is just speak about a couple of hot topics and things that I think are really kind of picking up some speed in the trust litigation world. And any one of these topics, you know, we could probably spend a whole day delving into some details on each of those topics independently. So this isn't necessarily meant to be that granular level, although I'm happy to discuss anything with anybody further if there's any questions after the program, or if there are any follow-ups, you're more than welcome to reach out to me. But so I thought I'd talk about a couple issues. And truly, I think one of the hottest topics and the topics that I think we as practitioners, both on the planning side of the equation, the administrative side of the equation, and also the litigation, is marital agreements. Marital agreements, I think, is a very significant sort of issue, and I think it's timely. And I think we're going to see an increase of that as we have decedents and grantors passing away who've had dissolution of prior marriages, multiple marriages, and other marital agreements. I think there are some interesting cases and developments in terms of some unique assets with respect to trust funding that we're seeing in terms of the litigation sphere. And we as planners and the planners in the room know the importance of proper trust funding and making sure that it's a cohesive plan and a holistic plan. But the fallout from that can be pretty significant. So kind of knowing what that is, I think helps us avoid those problems and helps us make us better planners as well. And I also think there's continued issue in the guardianship front, right? As the baby boomer generation is aging, and as we have people who are living with more chronic illnesses, we're living longer, our bodies are living longer, but the cognitive decline, I think, is significant, as well as people who are born with other types of disabilities, whether it's on the autism spectrum or any other kind of things. When and where we are planning for trust and planning for administration and how the litigation inspector could open up on that issue, I think is something to talk about too. So those are the topics that I've kind of thought we can kind of hit some highlights about this morning. And again, I'm happy to answer any questions if anybody has. So when we talk about marital agreements, Generally speaking, I'm talking about any agreement that impacts a marriage, whether that's colloquially referred to as a prenup, which is obviously a document that allows us to establish the rights and the obligations of the spouses prior to their marriage under the Domestic Relations Law, Section 236. Postnuptial agreements also is exactly what they think they are. They're agreements that happen after the marriage, which are not very different than a separation agreement. Sometimes you'll hear those referred to as the PSSA, the Property Settlement and Separation Agreement. Really and truly, the only different element of a postnuptial agreement and a separation agreement is really whether the parties are staying together. And then a marital settlement agreement, typically with respect to a judgment of divorce or other entry and things like that. But globally, all of those agreements taken as a whole are marital agreements and impact the overall plan. When you're dealing with marital agreements, we all know that we have a situation where we need to have a marital agreement in writing and subscribed to the parties the same way that you can have a deed recorded. And so there has actually been some interesting case law about what happens in the marital agreement enforcement realm when you have a situation where you have an incorrect notary or jurat or acknowledgement, and whether or not those are considered enforceable marital agreements for purposes of property division, usually upon the dissolution of a marriage, whether that is upon a divorce or a death. And so particularly as we're dealing sort of with the fallout from COVID, and certainly we have the series of Governor Cuomo's executive orders that have started with the April executive order that allows us to execute and witness and acknowledge notarial acts by video conference. You can easily see where this question of, is a marital agreement really legitimately executed, is something that we kind of take for granted right now, because most of the times it is. But you can see with the COVID crisis and sort of the remote execution of documents where disjoinery will happen. So when you're preparing those and when you're reviewing those, I would take a look at those acknowledgements and the acknowledgement clause and see if in fact it was acknowledged appropriately as of the date of execution, including the remote execution statutes, which is all at the top of mind right now. But in 10 years, 15 years, 25 years, when hopefully we've all moved past this crisis, we need to keep in mind those timeframes. A couple of things that happen too in terms of enforceability for marital agreements. I mean, ultimately a marital agreement is a matter of contract. And so the idea of full and adequate disclosure is one of the other issues that I think comes up oftentimes. When you're dealing with disclosure of finances, particularly for us as planners, oftentimes we get a call from a longtime client, whether it's a business client or a legacy client, and they say, I'm very happy my son, my daughter is getting married. They need a prenup. And so, of course, you doing your due diligence, you call the child who's getting married, the adult child who's getting married directly, and you have those conversations. And oftentimes that child doesn't necessarily know everything that mom and dad have. And they're not necessarily privy to all the trust planning or the business interest that you know of as the attorney. So there's always that sort of ethical tension there in terms of disclosing, making sure that the disclosure on the marital agreements are fulsome, but at the same time, who's your client and what is that client's obligation in terms of disclosure. One of the things that I kind of tend to do for purposes of financial disclosure, oftentimes we'll say outright, this person may have additional interest in trust. They are not the grantor of, nor are they the trustee of. And you can give opposing counsel your parent client's information. My apologies. Our office is eco-friendly, and evidently I was sitting still for too long, so my light shut off. But you can give your your opposing counsel contact information for the trustee, because again, your client, the client who is the party to the marital agreement, is only obligated to disclose what he or she knows or has in his or her dominion or control. And oftentimes as trust beneficiaries, they don't have much. And later you don't want to have any issue in terms of non-disclosure, which would give a defense for purposes of lack of enforcement on either a divorce proceeding or a proceeding at death. And then we still get oftentimes, and I don't know about everybody else, but we oftentimes get people who think that they can have the attorney for the deal, and if spouses agree, be in a position where they can just use one law firm to do the agreement because both parties are in agreement. And that's great. It's great that both parties are in agreement, but you absolutely want to make sure that you get and procure separate independent legal counsel for the other party for two reasons. You don't want to have a situation where typically the non-moneyed spouse is feeling browbeat in any way, because that's just not good for a new marriage. And number two, it benefits your client in terms of the enforceability section. So your client can voluntarily pay for the legal fees incurred by the non-moneyed spouse for independent counsel. But you want to make sure that the payment is not conditioned and it's truly the representation is dictated by that spouse who's seeking legal services. Generally speaking, when you're dealing with marital agreements, whether they're prenups, postnups, or any kind of separation agreement, mainly you're dealing with spousal maintenance and equitable distribution, intestate succession, exempt property, elective share issues. When you're dealing with a divorce decree or a property settlement, that's when you're getting into the land of child support and custody. You don't have those issues in a pre or a postnuptial agreement. The reason for that is the courts basically say, it doesn't matter what mom and dad say, the child has independent legal rights and we can set those aside in the best interest of the child. The only thing that you'll sometimes see in pre or post nuptial agreements that impact children is, and this is becoming, I think, one of the hot topics we'll talk about in a case study, but you'll see oftentimes there's a provision that requires one or both of the spouses to the marriage to leave their children a certain amount of their estate. And I think that you'll see more and more litigation about what that means. But ultimately, other than that sort of third-party beneficiary concept, generally speaking, you don't see issues involving minor children, their care, their custody, their child support in any kind of marital agreements. I think we all sort of know the benefit of marital agreements and how it is they can be helpful for our clients, particularly our business clients. Anytime you have a second marriage, I think it's worthwhile to sort of set forth the concepts in terms of the rights and obligations at death. Anytime you're a business owners, the last thing you want to do if you're representing the moneyed spouse or the business owner spouse is be in a position, sometimes it's less about the payment and the payment that's going to be made and more about the forensic evaluation that would happen for the company. If there was a litigation in terms of any type of economic rights to a surviving spouse or a divorcing spouse vis-a-vis the business. So the idea of having to open up the kimono and have a forensic evaluation done or an audit done in order to impute any kind of income or something along those lines to the either deceased or divorcing spouse is usually pretty unpalatable to most of our business clients. So being able to protect that privacy and make sure that you're in a situation where you have the ability for that business owner to define the process is sometimes more important than just the actual payment that would be made to the spouse on either death or divorce. And then oftentimes when we represent business owners or legacy family owners that have trusts or significant family wealth, and if we are disclosing that as part of the marital agreement process, which we encourage clients to do and be completely transparent and make sure the disclosure is proper and robust, oftentimes you're giving people very significant company information or giving people information about trusts from other generations of the family that your client, the moneyed adult child, if you will, barely knows. And so that's sort of an issue. And so oftentimes we'll paper that with an NDA. Your typical run-of-the-mill NDA has all exceptions for the receiving spouse to share it with accountants, lawyers, tax professionals, financial advisors. But what we don't want is to be in a situation where somebody is, privy to that information that they wouldn't otherwise have about businesses. Social media posts, believe it or not, is an area where we see issues with financial disclosure. So sometimes we'll paper that with an NDA, particularly for business clients or clients who have family wealth and legacy planning that is being disclosed as part of the marital agreement. And then interestingly enough, I think a lot of us have dealt over the years or recent years anyway, in sort of the evolving area of trust and estates law in terms of how we handle assisted reproductive technology and how we handle that oftentimes, again, can be addressed in the context of the marital agreement. Now, the one caveat that I'll say to that is, as I just mentioned before, courts won't allow you to dictate the lives of children as a matter of contract law if the child is not represented in the context of the agreement. So when you're dealing with assisted reproductive technology, usually you're dealing with things like who's going to pay for storage, who's going to be the owner of independent genetic material. Can you be in a situation where somebody uses genetic material from a deceased spouse after death? Those are the types of issues. It'll be interesting to see as we go and as the case law develops and the technology develops, how the definition of children applies to this area. So that's always something to kind of keep an eye out for. Well, one of the interesting things is oftentimes you'll hear people say, well, the prenup doesn't allow me to do something, even when you're representing your planning client. And one of the things that, I think is important to distinguish with your clients is a marital agreement, generally speaking, is a minimum obligation. It's what you can expect as a minimum from your spouse to do for you at death or divorce. And it's a minimum set of obligations in terms of what you would want to do for your spouse at death and divorce. Now, sometimes that's impacted if you have more than one marriage and you have a divorce decree and things of that nature. But generally speaking, a marital agreement is a floor, not a ceiling. And as we all know, the best prenuptial agreement is the one that sits in the drawer and our files for 35 years and nobody thinks twice because it's a happy marriage. And oftentimes you have situations where the marital agreement requires very little and may in fact include complete waivers of elective shares or things along those lines, but be that as it may, the spouses to a happy marriage may very well want to benefit each other fully. And so the question and where I think a lot of times the issues in terms of litigation comes in and we're seeing more of is what happens when there is a lack of reconciliation between estate planning documents and marital agreements. And that's when the difficulties, I think, arise oftentimes. Generally speaking, those difficulties can be broken down into two different items. What happens when you have a marital agreement that sets forth basic obligations, our floor, like we discussed, and the will or the trust or the overall testamentary plan doesn't give the spouse enough and doesn't give the spouse what he or she would be entitled to. And that's effectively what happens when there's insufficient dispositions for the spouse. How do you enforce that marital agreement? And generally speaking, it's a matter of contract enforcement. And typically it involves claims against the estate, claims against the trust. Oftentimes you see practitioners, they will object to probate and object to the probate of a will based on an insufficient disposition of a marital agreement. And sometimes that's fully appropriate. And sometimes that's wise and sound litigation strategy.
Excuse me, Jennifer, could you please give the attorneys their first code that they have to enter for their CLE?
Lorena, I apologize. I don't think I received those codes. Did I?
I'm going to give a code now of 4798. That is 4798. Thank you.
Thank you. So the concept is, I think a lot of times people will sort of reflexively object to the probate of the will, and that may very well be sound litigation strategy, and you may want to consider that. But if you're working with a situation where you have a litigation budget and that may not affect the end outcome, you may want to consider if it's the probate that you're concerned about, or is it construction? Is it reformation? Is it an issue when you really have an Article 18 claim and you want to litigate on a claim and you want to file a motion for preliminary injunction with a temporary restraining order to make sure assets are not distributed? Because again, the probate of the will, is this a will? Was this a valid will? And is this a will that's impacted by a contractual obligation that supersedes the testator's ability to do so, may very well be the question. So that's something to think about if you're approached and have that circumstance. And then ultimately, what assets should be used to satisfy any claim from an administrative perspective is always a valuation issue. If you're not dealing with liquidity and cash or securities, sort of how to satisfy the claim, and if you have to deal with any kind of abatement issues for specific legacies or devises in the testamentary instrument or non-probate assets, oftentimes is fodder for dispute. And so, you know, if you are representing the fiduciary at that point, making sure that you understand all the different areas that fiduciary could have liability, including if in fact you have non-probate assets, or you have a situation where you have a specific devise or legacy, you don't want to necessarily distribute those to the party to the marital agreement and then turn around and have your client have a claim by that specific legatee or devisee. So thinking about that in a holistic manner, I think makes good sense. So those are some of the areas to look out for when you have what I would call insufficient dispositions in the plan vis-a-vis the contractual obligations in the marital agreement. Frankly, the other area that I think gets even more difficult is what happens when there is even more that's given. And you may think immediately that the problem is, oh geez, the plan doesn't leave enough for the spouse, right? But sometimes more ambiguity is actually created when the plan and the marital agreement differ, so that the cumulative or aggregate effect of the dispositions results in more than is contractually obligated. And like we talked about, that's not a problem, and that often happens in sort of long-term marriages where it happens to have a prenup. But the issue truly is testamentary intent and contractual intent, and oftentimes is not handled well. So, for example, just a couple of cases to talk about. In the first case study, number 1, there was the estate of Newfield, and that was a Nassau County surrogates case in 1998. And the prenuptial agreement required that the surviving spouse receive not less than, quote, the gross estate. You know, what does that mean? Does that mean the gross probate estate? Does that mean the gross estate for, as finally determined by federal estate tax purposes? Does that include testamentary substitutes? Does it include life insurance? All of those types of things. And in this particular instance, the spouse also was the recipient of an IRA beneficiary designation. And so there was an argument between the surviving spouse and I think it was the children from the first marriage. And the children from the first marriage argued that the spouse couldn't take 1/3 under the estate because of the fact that there was an IRA beneficiary designation, and therefore it should be a set-off. And the court held no. The court said there was no set-off and the spouse received both. Case study number 2, matter of Braun, was a Westchester County case in 2012. And this was actually a very sad case. There was a prenup that we talked about earlier that required the spouses to create a trust for the benefit of future children. They hadn't had children at that point in time. And then sadly, the spouse died very young. I think as a result of a motor vehicle accident, and hadn't engaged in any kind of planning. And that's probably the easiest case that we've seen today, because the court found that the provision would be enforceable. And so that particular decedent had children, hadn't made a will, and nonetheless the court imposed a trust for the benefit of future children. And in this case, it was actually a decent outcome because of the fact that it obviated the need for a court-imposed guardianship. The Gersh versus Nixon Peabody case, 2017, was an interesting case as well. And that particular opinion deals more with the joint representation issue that was alleged by the surviving spouse. Then it really speaks to the ultimate, planning on the merits. This case actually settled, so we don't necessarily have a decision on the merits, but I think it highlights. I think it highlights the areas when we are dealing with a joint representation. In this particular case, Mr. Gersh was married for many years. He had a 1960s divorce, I believe in Mexico, that was ultimately transcribed into New York State, and it required to leave 50% of his, quote, estate to children of the first marriage. And of course, what does the term estate mean when you're interpreting that? And he remarried and had children. It was a long time second marriage, and they jointly went to an estate planning lawyer to do their joint plan. And their joint plan didn't necessarily address the issue of this divorce decree. And so as a result, the joint plan later upon his death was attacked by the children from the first marriage as third-party beneficiaries to the 1960s divorce. And ultimately, like I said, we don't have a decision on the merits for that one, but we do have a really robust discussion about the joint representation issues that kind of present themselves when we're dealing with second marriages and when we're dealing with issues of divorce decrees and marital agreements generally. So that's a nice read if you want to look at that area. Other case studies that you can kind of think about the issue. For example, we have a prenup agreement that requires $1 million Q-tip, and instead of the $1 million Q-tip, the testator left the $1 million outright, and the spouse argues that he is entitled to both the $1 million Q-tip and the outright bequest as sort of this voluntary over and above concept. The children argue that the $1 million Q-tip is consumed by the outright gift. And so query what the answer is on that. If in fact you are doing the estate planning, making sure that you have documented intent and the language in the instrument, is clear as to how and if that's reduced, I think is important. And if it's not reduced, having any kind of waivers in the file with respect to any rights that other spouse who'd be entitled to the Q-tip would be helpful. And unfortunately, in this particular case, neither exist. Case study number 5, there's a divorce decree that had, again, 50% of the probate estate, whether it's gross, whether it's net, we don't know, to the issue from the first marriage. So you had a divorce decree that controls. Then the spouse actually remarries a second spouse, and you have the prenup leaving 1/3 or obligating the spouse to leave 1/3 in a Q-tip trust for the second spouse. And of course, the actual estate planning documents follow neither of those obligations, and the trust left a pecuniary amount outright that violated both. So now you have the issue, in addition to sort of open interpretation, you have this sort of litigation fodder for what a divorce decree and a judgment of a court trumping somebody's ability to have a matter of contract, which is then, of course, would be subordinate to the issues in the divorce decree, which in turn impact the distribution of the estate and the trust. So thinking about how a divorce decree could impact a marital agreement, and all of which could impact, I think, your estate plan is important. And then we also had another case where we had a $5 million obligation in a prenup to be offset by, quote, testamentary substitutes, but not reduced down past zero. So the idea would be the surviving spouse wouldn't owe any money in if the testamentary substitutes exceeded the $5 million, which seemed pretty clear. However, in this case, we had all probate assets, with the exception of life insurance, would go to the surviving spouse. So the question the children argued is whether or not there should be any offset. So again, you know, when you're defining things, you think you're defining it easily by saying testamentary substitutes, but then of course, if you look under our EPTL, a testamentary substitute doesn't necessarily include life insurance. For purposes of the elective share, you know, you can include that for purposes of your marital agreement as a, quote, testamentary substitute. But that's when the precision in terms of drafting really comes into play. So with that in mind, I think, and I'm being mindful of our time, and I don't know, Karen or Lorraine, since we started a little late, if we anticipate going a little late, but feel free to let me know at your convenience. The other thing to think about,
Yes.
so I think, sorry?
Jennifer, I'm sorry, excuse me. Yes, if we'll go a little bit later, and right before you start your guardianship considerations, I would like to announce the second code.
Perfect.
Okay?
Yep, perfect.
Thank you.
Thank you so much. So that's marital agreements. And I think, again, like I said, I think marital agreements are really, as we have more parties to divorces and prenups who are aging, and as a result, dying, as we have more situations where we have individuals who have multiple marriages and interpreting the contractual rights and obligations and divorce decrees vis-a-vis those parties, I think is going to become all the more important. Another thing to think about in sort of trust litigation that I've seen is sort of what I would call funding issues and issues with unique assets. And when I think about those types of concepts, it has to do with general property issues, whether it's co-op apartments and proprietary leases, oil, gas, and mineral rights, foreign real estate for domiciliaries, and sort of the personal property matters that confound us all. One of the things that I'll mention is with respect to the co-op apartments, that's not something that we as Western New Yorkers tend to deal with as much as our downstate counterparts. Certainly there are co-ops, and we have clients who own co-ops, whether locally or whether in another major market area, but it's not something that we see with the same regularity that downstate counterparts do. And I think as a result of that, you know, they can be a bit difficult for those of us who don't necessarily look at them that often. One of the things that I would kind of caution everybody about that is when you're transferring and when you have sort of your trust planning and the idea of making sure your funding is spot on. Most of us say, let's get the house in, let's get the property in, let's make sure that we don't have, you know, an ancillary issue, et cetera, et cetera. And so when you have a cooperative apartment, of course, it's not necessarily that easy. Typically speaking, you would need full board approval. The board has to approve the terms, the residency, the length of occupancy, who are the beneficiaries of the trust. And oftentimes it constitutes a full closing, even if you are in a revocable trust situation where you have, you know, the prior owner is the primary beneficiary, primary trust, same taxpayer identification number. Nonetheless, it still constitutes a full closing. And so there are fees associated with that: search, survey, assignment of the proprietary lease for the actual units, things along those lines. So that's something to keep in mind. The other issue is there's a flip tax. And so you'll hear oftentimes people, especially again in downstate, talking about the flip tax. And flip tax is not really a tax. It's a misnomer. The flip tax is a fee. It's a closing fee, essentially, that is usually paid upon the closing of the transaction. And so oftentimes there are hidden fees to be aware of. And so the only thing that I would say in terms of co-ops is when you're dealing with a co-op and you're dealing with either planning or administration of co-ops, you want to make sure that when you're analyzing your funding, you're analyzing the whole issue. And if you're intentionally not funding a cooperative apartment, into a trust, that may be the answer if you want to avoid the flip tax, or if you want to avoid sort of the costs and expenses of the closing with the board, the HOA. That may be the answer, but ultimately you want to make sure that you document it. And of course, as we'll talk about in oil, gas, and mineral rights, the issue is, what is a co-op for purposes of your distribution sections? And so oftentimes the question as to whether or not a cooperative apartment and the proprietary lease constitutes a matter of contract, or whether it constitutes real property, is something that can be a trap for the unwary. So that's sort of the same situation when you deal with oil, gas, and mineral rights. And oftentimes us as New Yorkers, the oil, gas, and mineral rights that our clients use tend to be out of state. So if they have oil, gas, and mineral rights in their portfolio, and you're looking at funding, or you're in a situation where you're looking at administering an estate or trust that has out of state oil, gas, and mineral rights, determining whether or not it's a matter of contract or whether it's a matter of real property is an absolute necessary first step. You have to look at the jurisdiction of the state in which the rights lie. So when you are looking at, Louisiana oil, gas, and mineral rights, you have to look to New York law says you have to look to Louisiana law to determine if Louisiana says that's a real property interest or if it's personality. So you want to know about that. One of the things that we had a case, it was an interesting case. It was a 1984 trust and estate. There was a real property outright devised to the spouse, and then there was a residuary Q-tip for the surviving spouse. There was actually a corporate co-trustee. In this particular case, it was Plaquemines Parish, Louisiana, and Louisiana says that oil, gas, and mineral rights are real property. Unfortunately, the trustee and the executor, the corporate trustee and executor, didn't realize that. And instead of funding the oil, gas, and mineral rights outright to the spouse in accordance with the real property section, they thought it was a matter of contract. And so they distributed it to the trustee of the Q-tip. And then of course, the trustee many years later sells the oil, gas, and mineral rights to a bona fide third-party purchaser for value. And then everybody's chugging along, and that's fine. And she goes to resell the oil, gas, and mineral rights. And finally, a title examiner in the state of Louisiana realizes, lo and behold, this is a problem. It's a problem not only because of the fact that it was distributed to the Q-tip trust instead of the spouse, but there was never any ancillary probate that had been opened in the state of Louisiana because of the real property issues. So that's something that caused an incredible amount of expense. Of course, 30 years later, this is a 1984 estate. 30 years later, finding the trustees, finding the records, of course, the individual trustee, who is the son, was elderly himself at that point, had dementia, needed a guardian ad litem. The spouse for whom the real property devised should have been made to, she had long deceased, and she never had an estate, and she had a fully funded revocable trust. And so getting the parties to the table and getting the estates open, it was just a monumental undertaking and just incredible unnecessary expense. So when you're dealing with oil, gas, and mineral rights, and when you're representing, either the party to the plan when you're doing the planning or when you're doing the administration, just keep in mind, as soon as you see an out-of-state interest, looking to that state's substantive laws to determine if it's a real property matter or a contract matter, I think is very important. And then obviously when we're dealing with foreign real estate for a New York domiciliary, I think we also have other issues with respect to that, whether it's funded to a revocable trust, whether we have it in a single member or multi-member LLC, and how it reconciles with your tax clause. So if you determine that out-of-state real estate, whether it's an intangible or a tangible, and whether it's cited in New York State, there's a lot of analysis that needs to happen. And if you look at New York State tax law section 970 and the tax advisory memorandums on that issue, there's a lot of good information about that. But when you're administering your estate, and when you have a New York State taxable estate, and you need to make sure that you're looking at your tax clause to make sure that you're apportioning or non-apportioning the state taxes correctly in that issue. Another case that I will just mention, or another unique asset that gives rise to these difficulties when we're dealing with trust litigation, and is the funding of artwork and these obvious tangibles. I don't know about you guys, but I have these moments where you deal with really kind of complex business structures, very sort of high value assets, and those are relatively easy. And then inevitably the downfall of this family is going to be the tchotchke on the cupboard, or the piece of art, or the thing that doesn't necessarily equate to the amount of value that it has from a monetary perspective. Oftentimes has incredible levels of emotional issues. So making sure that when we're funding those types of assets into a trust, I think is super important. You know, there's a situation that we were involved in at one point. You know, there was a decedent who had a significant value of artwork. He made a charitable pledge of the artwork before his death. Then he made actually 2 different revocable trusts. It wasn't an amendment, it wasn't a restatement. The 2 different revocable trusts had different trustees, different beneficiaries, some charitable, some individuals, and all of which purported to have the Schedule A outlining the intent to fund this artwork to those 2 different trusts. And then, of course, we have the issue of the charitable pledge. Be that as it may, notwithstanding sort of the Schedule A and sort of the stated intent to contribute, this particular decedent also signed a consignment agreement with an art dealer prior to his death. So, you know, who owns the artwork? Was it effectively pledged? Could it even have been transferred into the first trust? Was it, you know, is Schedule A and sort of that schedule that we all attach to our trust agreements demonstrating that it's not a blanket trust, without more, is that enforceable? And, you know, I think depending on what side of the equation you are arguing, I think arguments can be made for both, although best practices for us on the planning side of the equation is to make sure that we have clearly demonstrated assignments into the trust, as opposed to simply the Schedule A, as well as acceptance. So acceptance documentation from the trustee demonstrating the acceptance, so that you fulfill the 3 prongs of the donative intent, so that if there's ultimately a challenge, that you have a clear file on that. Similarly, we had another situation where the dreaded Schedule A was not ultimately fulfilled. Decedent had LLC membership interests that owned various real properties and ultimately were sold, and so was the holder of certain promissory notes and mortgages. Ultimately, he then later created and funded a trust with several assets. Schedule A of that trust purported to transfer the LLC assets into the trust agreement. There was in fact a signed deed of gift, gifting those shares from the grantor into the trust. But there was no corresponding acceptance notated in the file for purposes of this particular trustee. And then the problem, however, was, of course, we had a situation where you had the corporate books, which were just the pre-ordered corporate books, the little, you know, black binder book. Nothing was completed. The tax returns weren't filed by this decedent in terms of where the income was picked up, because obviously we could argue tax estoppel. So the tax returns weren't done, and the trustee never collected rents and income. The decedent did, but never reported on the tax return. So you can see how that gives rise to significant issues. And interestingly enough, there are sales tax liens on that matter too, just to kind of round out the experience. The other thing that I'll kind of mention quickly in terms of unique assets, and I think we all are relatively familiar with this concept, is the concept of is it a convenience account or is it a joint account with a right of survivorship? And I think most of us appreciate that the whole convenience account argument under the banking law oftentimes is an academic exercise, because, you know, in very, very few situations will you see it be upheld that it was merely a convenience account. Most bank signature cards at this point that I've seen specify whether or not it was a joint account with the right of survivorship. And so the question of doing that, I think, is somewhat difficult. The interesting thing that I think is something to keep in mind, if you find yourself litigating whether or not an account was truly a joint account with survivorship rights, which would mean the whole to the survivor, or whether it was a convenience account that meant the whole to the presumed decedent, is whether or not you can argue that it was truly a co-tenancy. And instead of being sort of all to either side, is it an argument that you can make in terms of one half? And so I think the common law of moiety speaks to that issue. And I have a case there for you to take a look at, the estate of Hamburg, that I think speaks to that issue nicely. So if the signature card doesn't actually meet the strict right of survivorship language, you may want to look at whether or not you can argue a moiety, which would mean 50%, 50%, presumably, of the deposit account on date of death. So I think we all sort of hear the issue of the joint account versus convenience account, and we kind of go, oh, okay, yeah, I know that. But don't forget that middle ground. That middle ground can make a difference if you're talking about 50% of a significant account. So consider whether you can make that argument instead of just the joint account or the convenience account. And here are some of the factors that the courts will look at in determining whether or not it was a joint account versus a convenience account. And again, you can't meet those burdens, and if you don't have those facts, start with the signature card and determine whether or not you can make a moiety argument. And so I think those are the issues that involve sort of the funding considerations and the considerations involving some unique assets that are kind of coming to light recently. So with that, I think your second code is available.
Thank you, Jennifer. Yes, the second code, it is now 9:32 a.m. The second code is 61937. Again, that is 61937. And these codes are for the lawyers to put on the attorney affirmations. Thank you so much.
Perfect. Thank you, Karen. So the other thing that I just want to briefly talk about, and I'm mindful of the time and I want to make sure that we leave time for questions, is guardianship considerations. And I think we all well know the issues that are sort of present when you have somebody who's either disabled, whether they have reached the age of majority or otherwise, or somebody who has had capacity and no longer has capacity or has questionable capacity. And oftentimes I think those are really important and imperative understandings when you're dealing with trust litigation, when you're dealing with planning, when you're dealing with administration. Ultimately, you know, I think the goal as planners is to avoid and plan for these kind of contingencies and make sure that our documents don't necessarily have situations where we have an unintended guardian ad litem appointed, which is nothing against guardian ad litems. There are some tremendous guardian ad litems who do wonderful, wonderful work on behalf of sort of disabled individuals, or legally disabled individuals. But from the planning perspective, we don't necessarily want to leave that up to choice. So making sure that your documents are in order so that it can account for these concepts, whether that's including any type of issues for virtual representation for a known minor or disabled beneficiary, whether you enable or allow somebody to make a determination as to incapacity, including any kind of rebuttable presumption, whether that's somebody can overcome sort of a decision of incapacity in your document based on sort of a note or an opinion of a treating physician, things along those lines, I think help protect your fiduciary to make sure we are not in a situation where your fiduciary is compelled to go to court as opposed to being able to do it extrajudicially otherwise. You know, I think there's a lot of considerations for guardianship in general, and it's an interesting area that we should all be a little mindful of. Over the past 5 years or so, there's been a real push to get rid of sort of the plenary guardianships under Article 17A that were enacted prior to the mental hygiene Article 81 guardianships. And so you'll see there was a Southern District of the state of New York in the federal court system that had sort of a class action about whether or not Article 17A guardianships, plenary guardianships, violated due process. And so I think that's something that a lot of the judges are aware of these days and mindful of. One of the interesting things to kind of keep in mind, at least from my perspective, the Article 81 statute was designed to address people's functional limitations. They were designed to be the least restrictive means, and they were designed to address the functional issues. So oftentimes you're in situations where, you know, a diagnosis per se does not require or necessitate the imposition of a guardian. It's how that diagnosis impacts that individual's functional limitations that needs to be evaluated in order to sort of meet those burdens and standards of proof. I think the other thing, you know, that to keep in mind, I always indicate to people, and it's a little cliche, but I think it's very true. There's nothing more permanent than a temporary guardian in my mind. Oftentimes, I think there's very infrequently are we dealt with a situation where there's a temporary guardian, and that guardian, you know, if you're in a contested posture, that temporary guardianship is ultimately lifted without a significant amount of litigation. So making sure clients have surrogate decision making, making sure you evaluate whether the Family Healthcare Decisions Making Act applies, whether or not, you know, that individual already has a rep payee for their purposes of their Social Security benefits. You know, is there truly a need for a guardianship? And really sort of doing the due diligence and drilling down and doing an audit of those issues, I think is imperative to the petitioner. There is a fee shifting statute in Article 81, and oftentimes, you know, the courts will use that in this particular arena. And so the petitioner, if the petitioner is seen to have brought a proceeding that is of benefit to the incapacitated or the alleged incapacitated person, the court can and oftentimes will award all or a portion of the petitioner's fees, as well as the court evaluator's fees and the attorney of the AIP's fees, to be paid out of the petitioner's funds. Similarly, however, if there is sort of a bad faith filing, or if there is a filing that just doesn't meet the muster, the court can award the alleged incapacitated person's fees, including the court evaluator and the court examiner's fees, to be paid by the petitioner. So I think it's when you're representing a petitioning party, you want to be mindful of that. And, you know, I think it's a bit of a carrot and the stick, right? The law is trying to make sure that these are good faith filings, that they're not punitive, that they're not, you know, strategic in any way, and done in bad faith. But you want to make sure that you kind of give your clients that lay of the land first, because you don't want any surprises later. The other thing that I would consider too is if you're representing institutions, whether that's healthcare institutions or whether that's a corporate trustee who's petitioning for some reason, you want to think about sort of the confidentiality issues, particularly with medical records. If you're disclosing medical records, making sure there's a court order with the requisite findings. There's different levels of findings in the medical record arena. For purposes of any kind of mental health, substance abuse, HIV, or any of those other types of elevated burdens that you have to prove to show necessity outweighs the desire for somebody's confidentiality. So, if you're representing a petitioner facility, you want to make sure that you cover your petitioner so that they are not disclosing confidential or protected healthcare information in violation of their residents' privacy, whether it's HIPAA or any of the state privacy laws. So just keep that in mind. And if you're a trustee, query whether some of the financial records could be privileged as well. If there's a beneficiary, you may want very well to redact information in terms of some of the finances to protect the trust and maybe perhaps only disclose that particular beneficiary's beneficial interest in the trust. So something to think about as well. But I think as we sort of proceed, I think we'll see more developments in terms of Article 81. Something to keep in mind is sort of this pushback from the plenary guardianships under Article 17A, and really narrowly focusing and tailoring the set of rights that you ask for in a guardianship under Article 81 based on somebody's functional needs, I think is really crucial. And figuring out how they intersect with your trust or with your other agreements, and making sure that your agreements factor in whether or not a guardian or a power of attorney or an agent under a power of attorney can amend, restate, revoke, or sign waivers and consents under the general obligation law, I think is important. So with that, like I said at the beginning, I think those three topics are really, all of those topics we could spend a full day on. And I think there's some really interesting and compelling issues that I think are happening and are continuing to develop in the law. And I think we as practitioners in this particular area and professionals in this particular area are really well suited in order to sort of make sure that we're ahead of these issues. And as we tell sort of our clients, and as we tell, the people in our organizations who we have the privilege of mentoring, this is why it's important to be comprehensive, right? Oftentimes, I'm sure all of you get it too, you'll get the call where somebody says, I just need you to write a will. And it's like, that's not what we do. We're not document drafters, we're estate planners. The tangible thing that they may walk away with ultimately is a will, but that's not where the real incredible value is. It's everything behind the scenes, tying in all the beneficiary designations, making sure the funding is correctly done, making sure that we've reviewed all marital agreements, all divorce decrees, any kind of issues with that, and updating our plans holistically. And being mindful of, obviously, all of the different tax implications and any kind of future changes and challenges, which a lot of times I think has to do with capacity. And we will really see that increasing, I think, as our population, a large sector of our population ages. So making sure that those documents, call into play what happens if there's somebody who's incapacitated, whether that's, a future generation and some type of birth issue, or whether that's somebody who has declining capacity. That's where our value is as practitioners, I think. And that's how we can, I think, avoid our clients sort of these traps for the unwary and minimize litigation. So with that, I am available for questions. I'm very appreciative of your time this morning. I'm sorry that we were running a tiny bit late, but thank you very much for having me. I appreciate it.
So are there any questions? I don't see any questions. Jennifer, I want to thank you for a very in-depth survey of this area. I've learned so much this morning. And I also would like to thank Jeanette Townsend, CPA, for organizing this program this morning.
Lorraine, sorry to interrupt. I think I just saw that Lynn Carlton raised her hand. So I don't know if Lynn's hand is still raised or her.
There are two, actually there's two questions. Okay, we have in the chat box just some feedback, some very positive feedback for the program.
Oh, thank you.
I just want to remind all the participants to stay on the Zoom conference until the survey comes up. Again, thank you all for your patience this morning, and I think that we can all agree it turned out to be a very worthwhile program.
Thanks, everybody. I appreciate being able to attend. Thank you.
We will end the program, and the speaker evaluation survey should pop up as you leave. Thank you so much.
Thank you.